After studying this module, you shall be able to know the meaning of patents, copyrights and trademarks, learn to differentiate patent, copyrights and trademarks, identify the legal prospectus of intellectual property rights, evaluate the benefits of intellectual property rights. In the present globalized events of commerce and multilateral trade, the priority of any country to safeguard its intellectual property has become imminent. Thus, it gives statutory rights to the inventors and creators and thereby helps them to devote time and resources with zeal so that they can reap competent commercial value for their astounding efforts in the world of market. Symbolic developments in recent years have taken place in the legal system governing intellectual property rights. Categorically, intellectual property right can be divided into three parts. 1. Patents, 2. Copyrights, 3. Trademarks. Now, patents give absolute rights to the inventor to protect their inventions. Copyright provides the rights to the creators to protect their original work and gives exclusive rights to its use and distribution, usually for a fixed period of time, thus enabling the creator to get compensated for their effort. A trademark is an exclusive right which solely identifies the commercial source of origin of products or services, thereby not confusing the consumers about the authenticity and thus retaining the trust towards the quality. Patents. What is a patent? The word patent came from the Latin word patre, which means to lay open. Patent is a grant of property right to the inventor by an autonomous body or a sovereign state for bonded period of time. It is a document which gives detailed descriptions of an invention and thus set up a legal situation in which the patented inventions can only be fabricated, imported, used and sold with the authorization of the owner of the patent. Absolute rights granted to the inventors promotes more contribution of time and resources into the development of new and advantageous discoveries. The term of a patent is generally 20 years, starting from the date of application of the patent, filled from the government office. The Indian Patent Office is administered by the Office of Controller General of Patents and Design and Trademark, which is also called as CGPDTM. This is a subordinate office of the Indian government and administers the Indian law of designs, patent and trademarks. Patent Office is headquartered at Kolkata with its branches in Chennai, New Delhi and Mumbai. But the office of CGPDTM is in Bombay. It gives rights to exclude others from making, using, putting up for sale of selling or imparting the patented invention. Thus, usually patents are dubbed as monopolies, as the invention may not be adventured in the country by any person other than the owner of the patent, unless the owner agrees for such exploitation. However, the holder is authorized to take legal action against any violator exploiting the patented invention in the country without his permission. It may be noted that patent does not give any right to the owner to make use or sell an invention. Like any other property rights, patents are also a form of intellectual property. That is, it may be sold, licensed, mortgaged, assigned, or transferred, or simply abandoned. According to the national laws and international agreements of a particular country, the procedure for granting patents and its terms vary widely. Under WTO's agreement on trade-related aspects of intellectual property rights, patents applied should be accessible in WTO member states for any new invention in all fields of technology, and the term of protection should be of minimum 20 years. Patent licensing agreements are contracts where the owner agrees to grant the license to use, make, sell the invention to the license in consideration for a royalty or other compensation. If a patent is granted to more than one proprietor, it may influence the degree to which each proprietor can exploit the patent. Let's look at the features now. Proprietor of the design has patent rights for 10 years from the date of registration, but can be extended for another 8 years in a prescribed manner. Duplicating of patent design is illegal during the patent duration. Similarly, owner of design can sue for damage for any imitation of registered designs. Provisions of Patent Act 1970 applies in the same manner in case of patent design as in the case of patents. Let us look at the patentable subject matter. Invention must relate to a product or process or both. It should be novel, it should involve an inventive step, be capable of industrial application, and should be non-obvious. Some cases of patent violation. For example, Napster. In one of the internet's the most well-known intellectual property cases, the Recording Industry Association of America, that is RIAA, sued Napster, a file sharing site. Founded in 1999, Napster allowed users to share music files, and thousands of people began downloading songs for free rather than buying CDs. However, Napster did not own the rights to the music that people were uploading to its servers, where the music was stored and ultimately shared. The rights were owned by the recording artists and recording studios. The RIAA sued Napster and won, causing Napster to close its door or its servers, as the case may be. Napster now operates as a fee-based music download site and pays licensing fees for the music it sells. Bratz dolls versus Barbie. In 2008, Barbie was finally declared the winner in the long-running intellectual property rights battle between Mattel Inc. and MGA Entertainment Inc., the makers of Barbie dolls and Bratz dolls, respectively. In the lawsuit, Mattel sued MGA, claiming that MGA stole the concept and the name of the Bratz doll from them. Carter Bryant, designer of the Bratz doll, was an employee of Mattel, but also working as a consultant for MGA when he designed the doll. A few years after MGA began selling Bratz, Mattel sued both Bryant and MGA, alleging copyright infringement. Because Bryant was on the Mattel payroll and he created the doll, the Bratz name and design are considered trade secrets. The courts sided with Mattel and ordered MGA to pay $100 million in damages. Now let's look at copyright. Copyright is a right which is created by the legal organizations of a nation that grants the creator of an original and authenticated work exclusive rights with the sole motive of enabling the creator to get compensated for their intellectual effort. Act number 14 of 1957 governs the applicable rules and laws associated to the subject of copyrights in India, also known as the Copyright Act 1957. Copyright law in our country was ruled by Copyright Act 1914 and was primarily the extension of the British Copyright Act 1911 to India and rented largely from New Copyright Act of the United Kingdom of 1956. All copyright associated laws are ruled by the Copyright Act 1957 today. The Copyright Act of India is compliant with almost all international treaties and conventions in the area of copyrights. Copyright grants absolute right to the creator for its distribution and use of an original work. This facilitates the creator for their intellectual effort in the form of compensation. As patent, copyright is also a form of intellectual property. The duration of copyright is the whole life of the creator plus 50 to 100 years from the creator's death or finite period for corporate creation. This is primarily for authors, artists, journalists, photographers, or anybody else who develops non-material economic wealth. The minimum qualification to enjoy copyright. Copyright comes into existence the moment an authentic work is created. Now, as a copyright has come into existence due to the creation of an original work, it can be registered. The work of an author must be based on original creation and not unlikeness. Two authors may own copyright on two extensively indistinguishable works if it is determined that the cloning was coincidental and neither was copied from the other. Copyright is automatic and does not need any registration with any government. However, in jurisdiction where the laws provide for registration, it aids as a evidential proof of a valid copyright, and this enables the owner to seek statutory damages and attorney's fees. The publisher or author of an authentic work or the holder of or any other individual who is interested in the registration of the copyright in any original work may apply through an application to the registrar of copyrights. In reverence of the original work, the registrar may enter the details of the work on the receipts of the application after holding a proper inquiry of any work in the Register of Copyrights. It is not important to register. It results in the title of work or names, authors and publishers' addresses, name and addresses of the holders of the copyright being documented in the Register of Copyrights. Let's look at the rights attached to copyright holder. 1. Produce copies of work and sell them. Or 2. Import or export the work. Or to create derivative work. To display the work publicly. To sell the rights to others. Copyright is an authentic work is assumed to be violated when any individual does anything related to the work for which copyright has exclusively been given to the holder of the copyright for that work. Authorizes any location for the purpose of communication of the work to public for monetary gain if the communication violates the copyrighted work. It prepares for rent or sale or rents for hire or sells it or exhibits the work for trade and in turn get monetary profits, circulates or proposes for sale or hire any violating copies of an authentic work, presents in public and trades any violating imitations of a work, imports into India violating imitations of a work. An individual is assumed to have violated copyrights only if he or she acts in breach of a license allowed by the copyright holder or by the registrar of copyrights, without a license issued by registrar of copyrights or the copyright holder. It is felonious crime to deliberately violate a copyright. For such acts of violation, criminal proceedings can be proposed against the culprits. Infringing imitations of a copyrighted material or work automatically belongs to the holder of the copyright. Let's look at some recent cases of copyright violation. For example, Modern Dog Design versus Target Corporation. Case: Seattle design firm Modern Dog utilized a series of sketches of dogs in their compendium put out by Chronicle Books in 2008. The firm alleges that illustrations from that design have been used in a t-shirt produced by Disney / Target for sale and filed a lawsuit in 2011. Now, what was the outcome? There hasn't been a decision yet in this case, but Modern Dog has been campaigning online pretty heavily for publicity and funds to help with its legal fees over the issue. The Associated Press versus Fairey. In this case, famous street artist Shepard Fairey created the Hope poster during President Obama's first run for presidential election in 2008. The design rapidly became a symbol for Obama's campaign, technically independent of the campaign but with its approval. In January 2009, the photograph on which Fairey allegedly based the design was revealed by the Associated Press as one shot by AP freelancer Manny Garcia, with the AP demanding compensation for its use in Fairey's work. Fairey responded with the defense of fair use, claiming his work did not reduce the value of the original photograph. Now, what was the outcome? The artist and the AP press came to a private settlement in January 2011, part of which included a split in the profits for the work. Now, let's look at the punishments and the remedies. If the copyright in any work is violated, there are three kinds of legal action that are proposed. Civil proceedings may be proposed against an individual who deliberately violates a copyright. The holder of copyright license or the exclusive license can urge to the court for either prohibition or damages for imitation and otherwise, or detailed explanation of the monetary gains made, as it is an offence against the law to breach copyright. Violators may be punished or penalized with either legal confinement, that is imprisonment, monetary penalty, or violated copies of work are seized. A government can also be acquired in the form of anthem pillar order, in addition to above said civil proceedings. Above said orders can give directions to the opponents and allow applicants to pursue their premises for collecting proofs that of violation, and if any evidence found can be seized by the applicant. They are allowed to file a case if there is a strong evidential proof against the opponent, and thus criminal proceedings can be started. The violator is not cautioned ahead of the search. By doing this, the violator does not get the opportunity to destroy or hide anything. This ensures that he does not have the opportunity to conceal or destroy any evidence that can go against the violator. Now, what are trademarks? Trademark is a recognizable sign, design, or expression which identifies products and services of a particular source from those of others. The trademark can be obtained by an individual or business organization or any legal entity. It may be on a package, a voucher, a label, or on a product itself. Retailing of a specific service or good by the manufacturer or producer is well off, as by trademark cause of acknowledgement becomes effortless and there is an assurance of quality. The holder of trademark can forbid the usage of identical or comparable signs by opponents if any such mark can lead to ambiguous situation, thus raising questions on the authentication of the product or services to which the mark or trademark belongs to. By doing this, cheap quality imitation or below par standard substitutes will be and can be obviated from replacing genuine standard ones. Trademark is particularly a name, word, phrase, logo, symbol, design, image, or a combination of these elements, and it may be designated by the following symbols. For example, TM for unregistered trademark, SM for unregistered service trademark, and R for registered trademark. Let's look at the laws of trademark. Human beings have consistent inclination towards development, and for perpetual or constant growth, they have created and innovated things. The zeal to succeed and excel has always demanded constant time, sincere efforts, and resourcefulness. And after this devotion, man has scarcely failed, be it a handmade jewels, statues of goddesses and gods, or building floating vessels, etc. Initially, it all started by the need to specifically identify the ownership of the actual work and inhibited the thieves. By these marks, in the ancient time, the holder of below par quality goods were protected and the violators were automatically identified and punished. Two fundamental types of marks were found to be used in the Middle Ages. One, merchant's mark, and two, production mark. Let's look at India and its position vis-a-vis trademark laws. Some type of proprietary guardianship for trademarks in India leads back to several hundred years. Statutory trademark laws of India retrieve back to 1860. There was no trademark law in India until 1940. Specific Relief Act 1877 resolved abundant difficulties that inflamed due to infringement. A path-breaking act was passed in 1908, which is also known as Indian Registration Act 1908, in which, after declaring the authentication of the mark, its ownership can be registered under the law. The Trademark Act 1999 describes strongly acknowledged trademark as mark. The Trademark Act 1999 defines well-known trademark in connection or in relation to any services and goods. Trademark has ultimately turned into an important segment which in turn benefits and uses such goods that aids the usage of such authentic mark in connection to any other services or goods. It would feasibly be indicating or indicates a connection with buying, selling or interpretation of services between those services and goods. An individual benefits by using the trademark related to the specified services or goods. Thus, a trademark can be named as a tool that can give uniqueness and a way of description to a distinctive service and product. A growing number of countries also permit for the certification of less conventional types of trademarks, as in loan, colors, three-dimensional indications, that is packaging, shapes of products, detectable signs or aromatic signs. Similarly, a service mark is any word, name, symbol or device or any combination thereof that identifies and distinguishes the services of one party from those of others. Even a sound, skill, color, color combination or a shape can also be a service mark. Trademarks are of different types. Primarily, there are 4 types: certification mark, service mark, collective mark, trade dress. Examples of service marks. Examples of trademarks. Let us now summarize what we have done today. Intellectual property echoes the concept, or better we can say idea, that its subject matter is the yield of the mind or the capability of mind. Intellectual property is the yield or product of an artistic and innovative mind, and it is destined to changes. It can be imparted, bought, possessed, disposed of for the money and owned. As all this can be accomplished, they are destined to be issues connected that have to be handled. Patents and trademarks are very crucial features of intellectual property. Registered mark or any authentic work, be it the patent or copyright guardianship, has become substantial in the current competitive world, because every manufacturer or producer of a service or good will desire that his mark be exclusive, captivating, as well as it should be conveniently discernible from others. Creation of such a design or mark like this is utmost challenging, and after overcoming loads of challenges and difficulties, when violation takes place, it becomes very problematic for the creator.